into the court system and alternatives. And I usually start this chapter out every semester with one question, and that is, how much do you think attorneys make an hour? 300. Okay, that's a good, that's not bad. Usually somebody are like 150, 350 on up. Really? I mean, these days that's on the low end of the scale. And if you think about this, now I'm not very good at math, but let's say I spend an hour with you, then I prepare a pleading and that takes me a couple hours, and then I go to a hearing with you which takes 3 hours, and then I prepare some motion and that takes a couple hours, and then I go to the hearing and that takes me 3 more hours, and then I do some, I don't know, some prep for trial, and then I do jury selection, which takes me half a day, and then I do a trial, which takes me, I don't know, let's say it's 3 days. Getting there, getting into the court, meeting with you afterwards, say I'm at 24 hours. Anybody know what that adds up to? 44. And then you guys said 300. Anybody do the math real quick? 13.2 for a simple 3-day trial, not including if for some reason we go off to mediation. You're not happy with the result, we appeal, and we start the whole process over again. Yeah?
When you say not happy with the result,
you lose.
meaning you're in jail. And now you
Right. Well, in a criminal case, yes. You know, so, you know, something comes up that we feel is an appealable issue, and if I even do appellate work, and then I decide, well, we'll try an appeal. And, I haven't put in prep of witnesses or investigation or criminal discovery or anything like that in there. So minimum 15 grand. So a lot of people think, well, there's got to be some alternatives. That's why the second part of the chapter is there, right? And this can sometimes in a civil case take a long time. So, and it's not fun. If anybody's ever been through the process in any way, common thing is, be here at 9 a.m. So you're like, woohoo, good, I can be there, and then I'll be done, and I'll go about my day. You find out when you get there, everyone else has something that says be there at 9 a.m., right? So then you sit there all day waiting for your turn if you get it. If not, you come back. Meanwhile, I, your attorney, bill you for all the time, every time, and I can't work on anybody else's case while I'm billing you. That'd be double billing. Question?
How come if you have like an attorney you're up first?
How come if you have an attorney up first?
Yeah.
Well, I'm not sure it always works that way, but I think most judges are of the opinion that if you have an attorney, the attorney understands the process and things can go fairly quickly. But if you're representing yourself, you're kind of a issue, and it'll take handling, because I think a lot of times judges rely on the attorneys to handle it in their court. They're presiding, and they expect them to follow the rules and to have things in order. And now if you have a squared away attorney, you might even get higher up in the line, and they're like, oh no, not that attorney. I don't even want to hear from that person today. Right? So yeah, that could be one reason why. Another thing could be if you don't have an attorney, there are additional things that they need to do with you. Right? They're feeling like they need to explain to you everything versus your attorney should be explaining to you, and you should be ready to go when you walk in there. Typically, people who have attorneys with them take less time to deal with. All right, so in this chapter, we're going to talk about the concept of judicial review, look at jurisdiction, look at how a trial actually happens, and then, like I said, are there any other alternatives to this 15 grand or more that we may end up spending? Can you get out for less? Sure. I'm not saying every case is at least 15 grand, but you can go out there and find some statistics on what it costs a typical person who wants to try a case. It is definitely a big consideration. Not the only consideration. When I left the prosecutor's office and went into private practice, I had a guy come to me, very first case, good case, and he said, I don't care how much it cost. They always do. That was like my first lesson I learned is they do care, no matter what they say. And then he said, it's the principle behind it. It's not. It's how much it's going to cost. So that was the only time in my whole time of practicing an attorney I got grieved. He filed a complaint against me with the state bar, my very first client, saying basically I charged him too much money. And it was about this amount of money and about this type of case. And he was good every month. He met with me and I billed him and he paid his bills. But then when we got to the trial, take about 30 hours times $300. And I told him it was coming and he said it doesn't matter. It did. Right. So anyway, that is a major consideration, and usually one of the big ones. All right, so and we'll look at the idea of discovery, finding out what the other party has in a case. So judicial review. If you recall from last class, I said I'm not expecting you to memorize cases or years that they were passed. You probably have heard of Marbury versus Madison in some class before. The idea basically is that the judicial branch can review the actions of the other branches of governments to determine if they're constitutional or not. At the time, the legislature was saying, we create our own statutes, that's our business, you stay out. And the courts were saying, in order for us to determine if the government is acting in a constitutional way, I'm paraphrasing here, we have the power to consider your actions and the laws that you create and determine whether they meet the constitutional requirements or not. So, jurisdiction. On TV, jurisdiction's usually what? It's like where you are on a map, or the county line, or the police chasing you around, right? But jurisdiction here, in terms of the court system, it literally means the power to speak the law. So courts have power to speak the law. They've been empowered to do that. The question is, do they have the power to speak the law about your case? And if you read the chapter, you find out, for example, bankruptcy, maybe you already know this, is handled in which court system? The federal court system or the state court system?
Federal.
I've heard both. The federal court system. It's handled in the U.S. District Court, Bankruptcy Division. They've been given statutory authority to hear bankruptcy cases. No one else can. So if you walk into a state court here in Michigan and say, I'm broke, and let's say they should tell you, go down the street, right? You're in the wrong place. But even if they heard your case and they dropped the gavel and said, you're the brokest person we ever met, it's probably not the best word for it. I declare you broke or bankrupt. It wouldn't matter. They have no power to enter that order. It wouldn't be worth what it's wrote on. So, going to an attorney, one of their first jobs is determining what kind of case you have and which court is the right court to go to. In fact, when the attorney files a complaint, the first thing they says is, Judge, listen up. You're the right court. You have the power. We're jurisdiction of this area, or we're residents of this area, and this law relates to you, and therefore you can hear this type of case. Now, there's a couple major components to jurisdiction. One is having jurisdiction over the person. It's called in personam jurisdiction. And as it mentions in the second bullet, basically a power of the court to compel a person to show up, or a corporation, we're going to use that term interchangeably, to show up in front of that court in some kind of criminal charge or litigation. If it is a corporation, Every corporation has somebody it's designated to personally appear, to take service, and to get noticed and show up in court. Basically, the idea of this is, if you're getting sued or you're getting charged with something, you should personally know about it. If anyone's ever been served with a summons, that's what a summons is. Hey, you're being sued. You need to get down to that court, and you need to answer the complaint. And if you don't, you might have a default entered against you. Yeah?
What's the time requirements? They have to give you a certain amount of time beforehand? Is it 24 hours? Or?
No, you have, according to court rule and the type of case it is, it's a certain number of days, and that's stated on the summons. So it says, you're being served with a complaint. The complaint's usually attached to it, if it's that type, if it's a lawsuit that's being filed against you, and you have this many days to do something. Ask for a hearing, answer the complaint. You don't always want to answer. You might want to just say, you don't have jurisdiction over me. That might be your response. Otherwise, you should answer. Then the time runs, and the court says, where's the answer? And if it isn't one, they could enter a default against you. So it's a good idea not to ignore those types of things. All right. Now, even if you're not here in the state of Michigan, if you have property here, the court could exercise its jurisdiction over your property. So they go looking for you. They can't find you. They can't serve you. But they find that you have property that is yours here. If a default were to be entered against you, maybe there's something they could do with the property that you have here. Having jurisdiction over property is called in rem jurisdiction. And it's spelled up there, R-E-M. And so we might be talking about real property, personal property, or even intangible property like stocks. So generally, a court in Michigan has in rem jurisdiction over any type of property that's located within the boundaries of Michigan. So that's the first part, having power over the person or that person's property, or corporation or that corporation's property that's within the state of Michigan. The second part of it, well, this is kind of related to it, so let's do this kind of in between. Sometimes, even though you're not here, you've had enough contact here that the court can reach out and get you. You ever heard that phrase, long arm of the law? This is the statutory power of the court to reach out beyond its geographic boundaries and have jurisdiction over you, even though you're not physically here. And as that case indicates, sometimes, where you see this a lot is with corporations. Not every corporation is headquartered or physically located within the state. Depending on what kind of case it is, a lot of companies decide to actually have their headquarters in some other state. If you have a credit card, where is it from? Pass your credit cards up. Let me take a look at them. No. Now, what's a common place? Michigan, not so much. Delaware, Texas, places like that are common. Why? Right. They're treated well wherever they're at. And they must have laws that are favorable to creditors. So they go hide there. And then they extend credit to you. But this says, even though they're not here, if they extend credit to you here, then our courts have jurisdiction over them there. Does that make sense? Like, okay, you're somewhere else, but you extend credit to our citizens, therefore we get jurisdiction over you. But guess what they get you to agree to? If you have a dispute with them, where you got to go? To them. Or else they wouldn't be there. They're there because the laws there are cool for them. So if you ever have a problem with them, if you read the fine print, it says, go there. The case will be decided according to their state's laws. Okay, so there's a little bit of a game going on here. Think about that in terms of e-commerce. You know, there's somebody selling you something on a server in one state. They're located in another state. You're in a third state. You know, the question is, where are you going to go if there's a problem? You want them to come here. You may have agreed. You go there. All right. And what could that, basically the words that are used in this case, this international issue case, are sufficient minimum contacts. So if a company sells you a product in the state, that's usually enough. Often if they advertise within the state, that's enough. If they have an e-commerce site and you buy something, so like Amazon. What states have jurisdiction over Amazon? Yeah, pretty much all of them. So the question is, you know, if you want to sue Amazon, can you get jurisdiction within your state? Well, you may, but you may have also agreed that you settled a dispute according to another state's laws. Yeah.
International.
Right. Same thing on a broader scale. Like anybody ever sold anything on eBay? Like I've sold one or two things on eBay before, and I restrict who can buy my whatever it is because I don't want to deal with that. Because often, even technically, if our countries have reciprocal agreements where we could exercise jurisdiction over them, how easy it is to actually get a hold of them or even get your stuff. That's why when you get your stuff before you pay for it, and they want to be paid before you get your stuff. Yeah.
So when you do buy stuff and when they come up to this, like, do you accept the terms and conditions? Basically, is something in there saying, like, you got to follow this state's laws, or do you accept and keep going, then you try to sue them?
Yeah, I mean, I can't say for sure, but if you're a smart business at all, one of the fine print terms and conditions of any agreement is whose laws govern this transaction. You know, not just who pays for shipping, but if there's a dispute, you don't get what you expected. Right? That's why when you sell something through eBay, they say, not our problem. Like, you don't get your stuff, you contact eBay like, I didn't get my stuff from the seller. They go, we don't care. I'm paraphrasing. But basically they go, you already agreed in advance by having an account through eBay that we are only an auction service. If you didn't get something or you're not happy with what you got, see them, not us. In fact, you agreed to have it alternatively settled by some third party who does this kind of stuff. Yeah.
So you can open a dispute and you do get your money back if you don't get your product.
Yeah, I mean, they have some type of agreement now. Like, it's been a while since I sold it, where you can follow a process, and I think part of it depends on where the money's at and where's the good at. Yeah. Or if it's insured, or what type of agreements you've reached in advance. But generally, eBay, they don't want to get involved in the quality of what you received, and they're not. As far as I know, now I know they have some type of warranty. Somebody told me they have some type of warranty service that you buyer protection plan. Okay, again, another way for them to make money. That's kind of a jaded view. But you ever go to Best Buy and buy something, and there's already some type of manufacturer's warranty, and then they want to sell you a warranty? That usually costs more than whatever. No. Anyway, getting a little off track there. All right. So the other part of jurisdiction, in addition to getting jurisdiction over the person or the corporation or their property, is subject matter jurisdiction. It's got to be the right kind of case that court hears. Some courts are real specific. I gave you one example already. What was that? Bankruptcy court. They hear bankruptcy actions. That's it. You come up there with something else, they don't want to hear it. Other courts are more general. Now, it has unlimited there. Courts can't hear anything. What they mean is they hear a variety of different types of cases. So in Michigan, our district court and our circuit court, they hear a variety of different types of cases. Criminal cases, civil cases. Often in a civil case, the dividing line between district court and circuit court is a dollar amount or type of case or something like that. So usually those are the two categories, though. Either you go to the court that has specific jurisdiction to handle that type of case, or you go to a court where they hear a variety of different kind of cases, including your case. Another good reason to go to an attorney and saying, here's my issue, where do I go? They got to know. All right, so you need both parts of those, personal jurisdiction, subject matter jurisdiction. Limited jurisdiction is kind of an in-between thing. They don't have general or unlimited jurisdiction, but they may hear more than one type of case. The U.S. District Court hears a variety of different types of cases. Their divisions can sometimes handle specific types of cases. All right, and then another, whoops, a little too fast there. Another way of jurisdiction is, to look at jurisdiction is original versus appellate jurisdiction. When I say original jurisdiction, I mean trial court jurisdiction. I mean the first place you go to if you want to have a trial. So in Michigan, that's often the district court. Sometimes when you go to the district court, they decide that your type of issue is handled by the next higher court, and they send you there. Like, for example, in the criminal court system, you commit a felony, you go to the district court, they have preliminary examination to determine if it's a felony or not, and then they send you to the circuit court, and then you kind of start the process all over again. Basically, they have a hearing to determine whether they have jurisdiction, and then they say they don't, and then they send you somewhere else. All right? Appellate courts are not trial courts. Well, let me modify that a little bit. You may have a court that tries cases and hears appeals, but they're different functions. If you're talking about an appeal, you're not talking about introducing witnesses, arguing cases to juries. You're talking about looking at what the lower court did and deciding if it complies with the law or not. Does that make sense? Like if you go into the Michigan Court of Appeals, they don't have a jury box. They don't have attorneys examining witnesses on the stand. They're not introducing evidence for the first time. What they're doing is arguing an issue on appeal. Yeah.
So then, if there's new evidence found in the case, then would you still be appealing the decision, but it wouldn't be in an appellate court?
Well, it depends. So let's say you just had a trial, and then somebody comes forward and says, I lied, or I was hiding, and now I'd like to come forward. In some cases, what people do is they'll bring a motion for a new trial, right? And then that court that they just had the trial in decides whether that person's entitled to get a new trial or not. But later, if you bring an issue up on an appeal, basically what you're doing is arguing that the lower court somehow incorrectly applied the law. Does that make sense? Like if it's a factual issue, that's usually a trial court thing. You know, at appeal, they're not going, you know what, that witness seemed kind of shifty to me. Right? They're just saying, okay, here's the record of what the lower court did. Here's the law. You know, looks good, or they misapplied the law and we're going to do something with it. Basically, an appellate court either sends the case back. If you're taking notes, that's called a remand. R-E-M-A-N-D, sending it back. Like, hey, you lower court, you weren't paying a lot of attention. You misapplied the law. We want you to fix that. Or you failed to decide something you needed to decide, so decide it and send it back to us. Or the appellate court might reverse. It might say, as a clear legal issue, you decided it the wrong way. We're going to reverse you. We're not going to send it back to you for a second chance. We're just going to say you're wrong. Or the last one is affirm. A-F-F-I-R-M, affirm. We agree. We concur with the lower court. They did a good job. So back to what we started the class with. You could spend this money, then spend it again, and then the appellate court goes, yeah, we agree with what the lower court decided. Now you're 30 grand in the hole, and you're still in jail. prison or whatever. And you don't have a you don't have a good job to pay your bills. All right. So now let's start looking at specific courts. Let's start with a federal court system. Usually you get to federal court by one of two ways. Either you've got a federal question or diversity jurisdiction. Now, when I say federal question, I mean you got the type of question that federal courts hear. Specifically, you're alleging some violation of federal law or some type of U.S. federal constitutional claim. If it's a purely state issue, if you're arguing you have a problem with a state law and you're alleging it violates only the state constitution, you're not going to federal court. Unless there's another way you can get there. Get used to that. I keep saying, I'll say one thing and then I'll say unless, right? So there's always exceptions and exceptions to the exception. But here are the two biggies. Either you got there because it was a federal law, or diversity jurisdiction. And diversity jurisdiction has two components to it. Don't forget about both of them. You need to have all of the above. The parties are not from the same state, so there's diversity in who the parties are. And the amount in controversy is greater than $75,000. And this changes over time. The dollar amount goes up. It used to be 50, now it's 75. It'll be 100 grand soon. Yes.
Both of those, though?
Yes. Right. At the end where it says and, you could have people from different states, but it's a nickel and dime case. Or you could have a big case and everybody's from the same state.
In that case, it'd be in a state court.
Right. Yeah.
If you commit any crime on federal property, you're tried in a federal court.
Well, maybe. It depends. So, one of the cases that was here in Michigan was a guy who killed a mother and child on federal forest land. And then that was one of the first jurisdictional issues. How do we try him? Do we try him under a federal statute or a state statute? There's a variety of different considerations, from how much it'll cost, who will be doing it. It could be the feds and states pointing at each other and going, no, you do. No, you do it. Or it could be, I want it. No, I want it, right? But what do you think the big factor was? Why do you think that they wanted to prosecute him under federal law? Death penalty. Yeah. So, yeah, sometimes it could be concurrent jurisdiction. It could be both the state and federal law could have jurisdiction, and then we're either in a fight or trying to pass the case off, or we're just kind of trying to figure out which way we want to go based on what the penalties are. Same thing in the Oklahoma bombing case. Should we prosecute the person under federal law? Certainly there's federal jurisdiction. They killed federal employees in a federal building. Multiple federal statutes. But we also could have state jurisdiction because it was within a state and they killed state citizens. Yeah.
So is this Arizona shooter going to be charged under federal or state?
Yeah. Well, these are the type of questions. I mean, everything from what Arizona is doing in the terms of citizenship to, in that particular case, why would you charge under which law? Now, you can't just say we're going to prosecute under federal law because the penalties are greater. The federal courts would have to have jurisdiction. So in that case, how would you get jurisdiction in a federal court? So if it's a violation of federal law, if there's a federal statute that says assassinating or attempts to assassinate a federal official, then we could do it under federal law. So then that's what opens the door for federal prosecution. Yeah.
Okay, so for the amount in controversy
Mhm.
greater than 75,000, so if it's a case in which the parties are not from the same state, but it's like a murder case, then it couldn't be considered federal.
Oh, so it seems like we're spending a lot of time on the criminal aspects of this, but that's a good question. If we're not talking about litigation involving trying to recover a judgment, then the question isn't diversity jurisdiction, because this is a civil way to get to federal court. In the case of a federal prosecution, we'd be talking about where was it at, or what statutes, criminal statutes, would it potentially violate. So a common one is somebody kidnaps somebody here in Michigan and then travels with them, and the question is, where could you prosecute them? Every state that they went through, as well as under federal kidnapping statutes. And then again, we're not talking about dollar amounts, we're talking about which is the best place to be. And sometimes folks aren't all that cooperative, you know. Sometimes, like, no, we want to get them, right? Yeah. Well, you know, in a criminal prosecution, it may not be about the money. It might be, you know, anything from politics to, you know, yeah, how high profile the case is. I remember being in a prosecutor's office, and I would have people writing me letters from prison in another state saying, bring me to your state and prosecute me. I killed somebody there. They're buried here. Here's what I did. Right? Really. And you know, it turned out what they picked up from the papers or from their cellmate. Why did they send me a letter saying, I want to come to Michigan and be prosecuted there?
I didn't want to be where they was at.
What's that?
They probably didn't want to be where they was
They didn't want to, exactly. That's, you know, layman's term for saying they're on death row in the state that they were at, and they wanted me to bring them to Michigan where we didn't have the death penalty. So there's all kinds of things going on there. But in terms of ways that you can end up in federal court civilly, let's try this example. There's a lady, she's walking in Florida. A truck drives by from a company that's headquartered in Texas. Something falls off, hits her in the head. She's walking in Florida. She gets hit in Florida, but she's from Michigan. Let's say it's my mother-in-law. I love you, Mom. So, you know, because they're leaving, they're going to Florida, right? Now they're in Florida, and something happens to them down there. And it's caused by somebody who's from another state. So, question is, you know, maybe this is a good question on the quiz. You know, who has jurisdiction?
No, say I drove somebody across in most cases like that, it's going to be the state where it actually happened.
Right. One assumption is, well, the person ought to be able to sue where they got hit. You know, I'd go along with that. She's there. She's in a hospital there. I hope my wife never hears this. Yeah. But let's say now she's home. She's here in Michigan. She didn't want to go back to Florida. She don't want to chase them down in Texas. So, can a Michigan resident sue in a Michigan court claiming they were injured in another state?
Yes, because it's already by chance that it's interstate commerce.
They may make the argument that, you know, we're a resident of the state, you hit me, and I'm here, and it'd be convenient for the parties to come here and handle it here. What's that? Cash, did you say? Like costing more money? Like money, certainly cost is something to consider. Like you could go after them in Texas, right? Because they're headquartered in Texas. But I guess my point is, it might be Michigan, it might be Florida, it might be Texas, and it might be what else? It might be federal jurisdiction. When could it be federal jurisdiction? Right, because definitely I explained to you the citizens are from diverse jurisdictions, and the question is, how much are we talking about? So what would we say? We'd look at how much all of our expenses, including medical, are going to come up to, and we could potentially bring an action in federal court. Now, how do we pick? All the things you mentioned, right? How much it's going to cost, how convenient it is, what the laws are. You know, maybe in Florida, personal injury cases are capped at a certain amount. But in Texas, they do everything big in Texas. You can sue for an unlimited amount for personal injury. Or there's a lot of personal injury attorneys there who've lobbied to have no ceiling on Well, at some point, that would be logistically difficult, right? Like suing all states and whoever gives you the best results. At some point, the law is going to say that you got to pick, right? You got to end up somewhere. You got to commit at some point.
There is something stopping from.
Yes.
So basically,
Right. So, well, not double jeopardy because that's criminal prosecution, but there is a civil version of that. Like you can't sue somebody and then you lose and then go, well, I'll just go to Texas now and try it. Right? Same case, same facts, same statute, different state. Yeah.
What about like when you like sue someone like the guy that will sue Facebook and then they settled for so many $1 million and then they're going after him again?
Well, if I understand the case you're talking about, guy who says he's actually part of the start of Facebook and under contract law was entitled to a portion of their earnings, right? So you're saying if they settled, what was the terms of their settlement, right? Does a settlement in a contract action necessarily prevent somebody from bringing another action under a different claim for a different issue? So yeah, I mean, these are very complicated questions. Certainly, if I'm an attorney representing Facebook, wouldn't that be cool? I'm going to make sure if somebody settles with me, I'm going to say they got no claim against me ever for anything. Yeah.
So for the diversity ones,
Yes.
if it meets those criteria, does it
Yes.
have to go to Facebook,
No.
or it just can?
No, it can.
Okay.
Yeah, so all of this these are the potential courts that could, so therefore there's the potential for concurrent jurisdiction within the state or within the state at the federal level, and then you go about that game of figuring out which is the best place to go. Now, usually what the logical next question is well, who decides that, right? Often it's who gets there first. You got a claim, go to an attorney, and the attorney takes a look at the different states' laws and then decides. I get calls all the time from attorneys from other states asking if I can take a case within this state because they don't practice here, they don't know the law here, and they just look up my name and then contact me. Yeah.
I didn't hear what you said about if you get tried and you lose the case in Texas.
Yes, you're done. Right. It's not double jeopardy, but there are civil laws relating to whether you can take two stabs at the same party for the same thing in different places. Yeah.
Like, say your mother-in-law wants to sue the man because she lost to the couple, and she turn around and sue the man.
Right. So you've got a claim, and when you bring your claim, instead of suing everybody, the trucking company, the person who hit you, the sidewalk manufacturer, I don't know, anybody you potentially can, you save your claims. Well, then later, one of the arguments by the other party is the civil procedure required you to bring all claims that you would have at one time. Now, not saying that the court's going to necessarily go back to the Oklahoma Obama case. They prosecuted federally, and then they reserve the right then to bring a separate action against killing state citizens in case they didn't get the penalty. At least that's my argument in the first case. Yeah.
Then could you, let's just say it was a criminal and a civil case, could you try one in a civil and one in a state?
Well, yeah, let's say that the truck driver was intoxicated and ran over my mother-in-law and killed her. I'm really in trouble. So now the person who was driving the truck has criminal responsibility and could get sued civilly for that.
Could you do those in those two different states? Could you do criminal in Texas and civil in Michigan?
Well, I mean, we could keep going just to make sure that the questions you're asking help you understand the two ways you get to federal court. But yes, you could, that state could bring a criminal prosecution, and that's usually the way it works. Like, you were on Florida's roads, and you killed somebody within our state, so the criminal prosecution happens here. But yeah, the person could bring a civil cause of action for wrongful death. The state could. Yeah, you could. In fact, here, that's a good lead into this, is that in some situations you have what I mentioned, concurrent jurisdiction, where you've got a federal question and a potential state claim, so more than one court could potentially hear your claim. In other cases, you're in one or the other. Like if you look over on the left, it's exclusively federal jurisdiction if it falls into one of those categories. If we're talking about only a federal crime, or we're talking about intellectual property disputes, or we mentioned bankruptcy as an example, or admiralty, which has to do with the high seas. So then you know which court you're going to. Because you go anywhere else, they're like, what are you talking about? We don't do that kind of stuff here. And then over on the state side, if this will trip you up, don't let it. If it's purely a state claim, then you go to state court. The United States Supreme Court does not have jurisdiction to review purely state claims. They're not looking around, watching everything all the states are doing within their states, and if it's purely a state issue, trying to second guess them. They get involved. The federal court system gets involved when it's a federal question or there's diversity. And in some cases, there are some rare situations where you get to go directly to the U.S. Supreme Court. But, yeah. No, I mean, a lot of people travel all over the place, and at some point they petition for bankruptcy. Usually they petition for bankruptcy where they're at. Now, we're going to get to the second part of that is there's a number of bankruptcy courts within Michigan. Which one do you go to? But that's coming. All right, so like if you're going through adoption or divorce, you can't get to federal court. Right? Because those are state issues. You don't argue, well, my wife is now somewhere else, so there's diversity of citizenship, right? You know, you are in a state court. So they have exclusive state jurisdiction. So the colors there are supposed to show there's some kind of overlap. Is that right? Blue and yellow make green? And it's been a while. All right. Now, all this, did you see that? I don't know, maybe some of you were looking down. I want to show you the multimedia sliding scale. Right, one. Yeah. All right. We've been talking a lot about you're within Florida or your company's from Texas. We've been talking a lot about state lines. Well, on the internet, at least after Al Gore invented it, maybe if I use it more, I can win in my lawsuit. There aren't all these state boundaries, right? You're buying a product from this place, which you're getting it from this other place. You know, you're dealing in interstate commerce. So it's more of a sliding scale when you buy something online. You know, if somebody just has a website that says, this is who we are, you can't buy anything through it. Usually, we call that a passive website. That doesn't entitle every state to have jurisdiction over them. But if you're an e-commerce site, then every state that you sell a product in now has jurisdiction over you. That's something to think about. Is anybody into entrepreneurship and starting their own business, potentially having an online store or something like that? Well, if you are, then understanding you're reaching out to any place the internet can reach. And when you do, now they got jurisdiction over you. Yeah.
Registration or fees or something count as e-commerce?
So like if are you talking about registering a domain or web hosting in another state?
If someone has to like register to be pay to register to be part of your site.
Ooh, that's a good one. So your site is not really selling a product, your site is offering a service. Yeah, I think so. Yeah, I mean if you're selling a service, not a product, I don't think that changes squat.
I guess I didn't think of it as a service.
Well, offering web services, sign up to my site and you have to pay. As soon as you start making people pay, yeah.
What if things aren't being purchased directly through the website? So if it's like advertising something, but then it's paid for by a check, or you know what I mean? Like if somebody's buying a dog in a different state and they send a check instead of buying it directly through the website.
Yeah, I mean there are people who do all kinds of things to get around things, but you know, I think in the end, there isn't like hard and fast rules. There may be cases out there on that, but the real point of this slide is that each case is decided on an individual basis, and they're going to look at how much contact seller had with buyer in their state. And if they go around the site and ship a good to that state and there's a check cut, the court may still say, well, you didn't do it online, but there still was contact within that state. So, I mean, that's a good point. I mean, there are lots of places who don't, you don't pay the site. My wife told me about Etsy. Anybody ever heard of Etsy? It's like a craft site type thing. You know, they don't sell the product. You sell your product through the site. So, yeah, that could happen. All right, and then, you know, potentially that could be even at an international level. We talked about that. All right, venue is a little different. Don't get these confused. You're going to have an opportunity to confuse them soon, but don't. Venue has to do with the most appropriate geographic place to have your case tried. Well, let me give you an example. You want to file a bankruptcy petition. You're in Grand Rapids. You have creditors all over the place. A lot of them are around here. There, you investigate and you find out there's an Eastern District of Michigan, there's a Western District, there's Northern. I mean, there are a variety of bankruptcy courts that you could file in. Venue has to do with the most appropriate location for the trial. When a number of courts have jurisdiction over the case, which is the best court to go to actually try the case? So if you're here, most of your creditors are here, then you file a bankruptcy petition in the Western District of Michigan, right here in Grand Rapids. Parties can file motions saying that this isn't the most convenient place. A lot of times you hear about that in criminal cases, right? You know, a motion to change venue. Remember Scott Peterson, the guy who chopped up his wife and unborn child, and he was always dyeing his hair and trying to run to Mexico? You know, at one point in the trial, he's like, people don't like me. So he wanted to change venue to somewhere else. Right? Same thing in the Oklahoma bombing case. The guy who wasn't killed, Terry Nichols, is that right? The Michigan guy? Yeah, he what's that? Oh, okay, good. He asked for a change of venue because he claimed people didn't like him. You know, I'm paraphrasing, but arguing that you're not going to get a fair trial where you're at because there's unfair publicity or the court is somehow going to be biased towards you or something like that. So that's another way that we look at the most appropriate place to hear a case. So don't get the two confused. Yeah.
Is it a certain? Does it got to be a certain level of a case to be able to change your venue like that?
No. If you're talking about levels of cases, do you mean like dollar amount? Do you mean type of case? What do you mean by when you say level?
I don't want to keep saying criminal, but say for instance, you was being tried for a criminal case and you wanted to change your venue because you kept seeing that judge over and over again, and he kept attacking you.
Right. Not uncommon. If you stay in the same place and you keep doing stuff in the same place, that you might keep seeing the same judge.
Right.
And then you argue, well, that judge doesn't like me. That's not an uncommon argument. And it might even be true.
Yeah.
Usually, though, you don't ask for a change of venue to another state or county or something. You ask for a different judge.
Oh, you can do that?
Yeah. But guess who hears the motion?
The judge
Yeah.
that you want to change?
Right. You're like, Judge, there's this judge that doesn't like me. And they're like, you mean me? Yeah. Well, I like you. Actually, I like you a lot. I see you all the time. So yeah, sometimes that doesn't go very far. But you could, in a criminal case, ask for a change of jurisdiction to another county because you don't feel that county has been fair to you, or the law enforcement is against you, or whatever the issue might be.
You gotta put it in motion for that also.
Right. You can't just say, I don't think they like me. You have to be formal about it. But can you guys articulate the difference between the two now? Jurisdiction has to do with the statutory authority of a court to hear the case at all. And there might be more than one that could. Like I gave you that example of bankruptcy court. So jurisdiction has to do with whether that court can hear the case. Venue has to do with, okay, yeah, the court can hear the case, but which is the best place to have it? The trial. All right, and then a third concept here is the idea of standing, or standing to sue. I use those terms interchangeably. Standing has to do with being the right person to be in court. And there's two parts to it. One is, did it happen to you? So let's say you come to class one day and you're telling me the story about something bad that happened to you, and I'm like, man, that really makes me feel bad. I'm going to sue and get money for it. Right? I can't recover for what happened to you. Even if I was an attorney representing you, which I wouldn't, but if I did, it would be for you, not me. So whoever actually suffers the injury, notice it says legal injury up here. Legal injury could mean physical, economic, whatever. That's the party that has to bring the action. They may use an attorney, or they may have a guardian or something like that, but it's all about them. And same thing with a company. If a company sues, then the right party who's authorized to represent that company has to do the representation.
How does that work with parents or guardians?
Right. So something happens to a child, the child's not going to bring the action, but the guardian or adult needs to bring the action for them, or have an attorney that represents the child. All right, so that's the first part. You got to be the right party. And the second part of standing is, and it has to be a real case. Like say I'm driving through McDonald's, and my kids are like, give me a happy toy, give me a happy meal, give me a happy meal, I want a toy, right? And so we get a happy meal, and it has a toy in it, and I look at the toy and they go, you could have choked on this, I'm going to sue. Can I? Am I the right party? Sure. I'm representing my kids. But is it a justiciable controversy? Which means, is it an actual thing that really happened? Or is it a hypothetical? It's hypothetical. I said, you could have choked on this. So I got to let them choke first, and then I can sue. No. I'm only bringing an action for something that really did happen, not going to court and saying, Judge, this might have happened to me. Yeah. Hearsay. Well, hearsay is a rule related to you in court testifying about something that somebody else said or you don't have direct knowledge of. So, like you're saying, if you heard that something happened to somebody else, could you do that? No. Right. Yeah, that's a little different issue than standing. Right. So make sure you have both parts. If you see this coming up anywhere, make sure that it's something that really did happen and that this is the person it really happened to. All right, court systems. Don't pay any attention to the Texas part. Pretend it just says state courts, right? Because names of courts differ by state. Like in some cases, the superior court is the lower court, or in some cases, in the highest level within the state, it is called the Supreme Court. In Michigan, it works out pretty well. Michigan has a district court, court of appeals, and Supreme Court, just like this Texas courts diagram. But what I want you to remember is that in any state, there are 3 levels. There's a trial court level, and some of these little courts down here that feed into it, we're talking about magistrates, traffic court, small claims. There's some trial court level, there's some appellate court level, and then there's some highest court in every state. Sometimes it's called the Supreme Court, but it's not in every state.
So there's only those 3?
Yep, there's those 3 levels. So there's always a court within a state where the buck stops. There's always some appellate court system, and then there's always some trial court system. And like it shows here, that might have a different name, or it might be a different court, but it's at the trial court level. In other words, there's always a place you go to have the trial. There's always a place you go for the appeal, and there's always some highest place where everything's going to stop if it's purely a state claim. And then if it doesn't involve some kind of federal diversity issue or federal claim, it's not going past that. Yeah.
So what would the court of criminal appeals do?
Well, they're not really organized by criminal appeals, but there is a court of appeals that considers legal issues in criminal cases. And so their job is primarily to say, here's the case law and statutory law that's out there. Here's how we've decided courts in the past. And looking at the record of the lower court in a criminal case and deciding whether it's...
So, but it said it goes from the court of appeals, then there's that court of criminal appeals.
on this slide, you mean? Or yeah. So don't pay attention to the names.
Okay.
Or just think trial, appellate, Supreme, or highest court. So in Michigan, there's not like a Supreme Court of Criminal Appeals and Civil Appeals. There's a Supreme Court, and then there's an appellate court system. Yeah?
How do you get, to go to, a Supreme Court type thing? Like Roe versus Wade, that didn't really have much of...
Well,
it became because it had federal law.
So are you saying, how do you get to the U.S. Supreme Court?
Yeah, how does that become, how do they decide that? Because they could have just made it a state law, but instead they decided that they wanted that to be a trust.
Yeah, the way you usually get to the Supreme Court is either you have an important U.S. constitutional claim, or you've got a case that the U.S. Supreme Court has jurisdiction over that they really want to take. I guess there's the third way I mentioned earlier, where the Constitution says you get to go there. There's between ambassadors, between countries, between the states. Like if Michigan and Ohio had a feud, not citizens, but the state itself had a feud with each other, where would they go? I mean, they got to go somewhere that's not, one of those states, because they're like, come over here, we'll be fair. So in rare cases, you could end up in the U.S. Supreme Court. So yeah, most cases you end up getting there, and I think there's a slide coming up on there, by asking if you can go there. And they go, where they pull out their little checklist and they go, is it purely state claim? Yep, okay, go here. Is it a really cool case we'd like to hear? Yeah, maybe we'll hear it. Or is it an important U.S. constitutional claim? Now the question in that case is, is in that privacy rights area, is that important enough for us to hear and decide? If you think that's a privacy issue. All right, so here is how a state trial happens. We started with a federal court system and how to get there. Now, generally, not referring specifically to Michigan or Texas, you've got some kind of court, which is a court of record, where they make a record of your case. Now, not every case gets reported and put into books that you can pull off a shelf, right? There are certain cases that do get reported and finally put into print somewhere. most cases are actually, there's some type of record of them, but they all don't end up in books somewhere. You've got an opening and closing argument. You've got jury selection where you're trying to pick a fair, impartial jury. You've got evidence that's introduced in a variety of different ways. Witnesses that are introduced and cross-examined. And at the end, and there's going to be other slides that kind of break this out, but this is the flow of it. You've got a verdict or a judgment. Verdicts are by juries. Judgments are by judges. And then after that, you might have an appeal where you say the jury didn't know what they're doing, the judge didn't know what they're doing. That's the way, a big picture view of how case law works. And then the appellate court, which is a kind of repetition of what we already said, they consider questions of law. They are not trying to second guess what the jury thought about a particular witness. They're not deciding questions of fact. They're taking the lower court's determination of fact, the record of it, as the truth, and they're looking at questions of law. And they typically do that just by looking at the lower court record and hearing arguments from attorneys that represent the sides. All right, the state Supreme Court, as we mentioned earlier, it may not be called the Supreme Court, but I mean supreme as in the highest court. They're known as the court of last resort. And there is, if we're talking about the U.S. Supreme Court, then there's a couple ways you end up there. You end up there because the law says you get to go there as part of the appellate process. But in most cases, you end up there through a writ of certiorari. That's how you say that. And basically that writ is, hey, Supreme Court, you really ought to hear this case. Please, and they could say no or yes. Question about? Yeah, sometimes at a state level it's called something else. Like the example they give you up here is the Texas Supreme Court. In Michigan it's the Supreme Court. But in other states it's the highest court, but it has a different name. But still, same thing as state system. Somewhere you run out of appeals. Like you, on TV you always hear, I'm taking this thing all the way to the U.S. Supreme Court. And you should yell back at the screen, not if it's not a federal question or you have, because it's, somebody who's on Judge Judy or whatever, they're probably not going to the U.S. Supreme Court. Right? But they're yelling they are. All right. And then in the federal court system, again, I'm not going to, there's a map in the chapter and colors and all that type of stuff. I'm not going to expect you to remember Court of Appeals number. We're in the Sixth Circuit Court of Appeals, but again, there are these levels. There's a trial court, and in the trial court system at the federal level, it is called the U.S. District Court. Then there are these Circuit Court of Appeals. In other words, there's appeals that are handled across multiple states in the federal court system. And then there is this one highest court, the U.S. Supreme Court. And most of those cases, if they ever get up that arrow, those arrows in that direction, get there because they apply for, and they're, most of them are turned down. Most of them never get that high. All right, yeah, so here's the diagram. You don't have to memorize this. You can see that, we've got Wisconsin, Illinois, and Indiana, which are actually in a separate circuit, and the Sixth Circuit is Michigan, Ohio, Kentucky, and Tennessee.
Who put Puerto Rico in with Maine?
I don't know. I think they were breaking up all the regions, and then they looked at it and went, oops. All right, let's just throw in these other ones out here with somebody. Yeah. That's a good question. I wonder if you Googled that, it would give you an answer. Like, type the question in a search engine. Who put Puerto Rico in with Maine? Our provost here is from Puerto Rico. Maybe I'll ask her. She might know. All right. So how do you get into state court? You file a complaint. You say, Judge, you have jurisdiction. This person did me wrong, and I want you to do something about it. And then you go out and you serve the complaint with a summons on somebody, and then they get to answer you or ask for it to be dismissed. Potentially, maybe they ask it to be dismissed because that court doesn't have jurisdiction over them. It's not the right type of case, or they're not there. And then maybe some pretrial motions. There's a couple listed up here. One is basically saying, judgment on the pleadings. Hey, judge, you got everything you need to decide this. It's all right here. You decide the case right now. Or motion for summary judgment. There's only a real specific legal issue that needs to be decided, and then the case can be disposed of. We don't need a full trial on it. Yeah?
Is the star, like, on the map, like, is that where they're...
Yes, that's the seat of the circuit. Is that what you're talking about on that last slide? Yeah. Cincinnati.
Yeah, just like the star.
The center.
And then that's why there's the circuit.
That's why what?
For DC. There's
Right. Mm-hmm.
I was just trying to figure out what all the stars were.
The stars are the center of the circuit. Not the center geographically, but where that Court of Appeals sits. Right? And so there's panels of judges that sit and handle those cases. I don't know. WNE? Where? Right. Oh, okay. Yeah, they're regions within the state. So there's central, eastern, northern. Same thing here. Right. So, like you remember earlier when I was talking about bankruptcy court, and I was saying there's western and eastern districts. Yeah. There's actually more refinement than the author has in this, but that's pretty much. Yeah. So you guys are kind of into maps, I see. I'm not going to ask you those type. I mean, it's good to know. It's interesting stuff, especially when something happens to you. Question is, where do I go? All right. So discovery. On TV, it's always like in the last 5 minutes of the episode, somebody surprise comes forward and solves the whole case. But that's not the way it really works, or shouldn't work. Discovery is the process of finding out what the other side is going to do at trial. What witnesses are going to introduce? What evidence do they have? So you ask. Like, you don't just say, let's just wait until trial and find out what they got. Right? You use these tools to find out what they plan on introducing at trial. Deposition and interrogatories. We're talking about questioning the other side. Deposition, oral testimony taken under oath. So maybe you depose a medical doctor or somebody before the trial. Interrogatories. You send them written questions which they sign under oath. Maybe there's some things you'd just like them to be locked into and get them done before the trial. Then you can hold them up and say, look, earlier you said this. Now you're saying something else. Maybe there's medical records or documents that they have that you want. Maybe you want them to admit to certain things, kind of narrow in on the issue. We admit that you're a citizen of the state, that you were incorporated in this year, that you did this on this date, whatever it is. And then electronic discovery. I mean, we're broadening this, not just documents, pieces of paper. You know, what emails have you sent? Who'd you send them to? So there's a variety of different types of discovery. Attorneys really need to do this, or, you know, I'd argue it's malpractice. If you're an attorney and a client brings you a case, you need to find out what the other side has. You need to find out before trial. And you need to consider all these things. Not just a typical request to find out what they have in their files. You want to find out what they're hiding electronically. Then a pretrial conference, which really has two purposes. The official one is to get everything ready for trial. find out if there's discovery's been done or if we need to have more discovery, when the trial's going to be, how many witnesses, how many days. The unofficial other reason is to get everybody to settle. Like the judge really doesn't want to have a trial, so pressures you at the pretrial to get the thing settled and taken care of. And then jury selection, or voir dire, is where you ask the jury questions. The official reason is to make sure that they aren't biased. The unofficial reason is to inform them about why you should win. So you're telling them something about your case. And I say that. You're not. Judges like to slap your hands if you try to persuade juries during questioning. So you shouldn't be making your opening argument, closing arguments to juries. But sometimes juries don't know a lot about whatever it is that you're talking about. So you have to ask them questions about, have you ever been involved in this kind of case? Do you know what this case is about? All right. Then during the trial, we have our opening arguments. Then the plaintiff goes first. Why? Because they have to, because they're the one that's complaining. They're the one that has the burden of proof. In a criminal case, if the prosecutor charges, then they have to go forward and prove the case that they claim. In a civil case, the plaintiff's arguing, I was injured. They have to go forward and show the court how they were actually injured. So they have the burden of proof, which we mentioned earlier is either beyond a reasonable doubt in a criminal case, so they have to meet that burden, or a preponderance of the evidence in the civil case. Then the defense goes. And then the plaintiff introduces their witnesses, then the defense introduces their witnesses, and then there's closing arguments. Wrapping it all up, this is why we should win. Then a motion for a directed verdict is, Judge, before the jury decides anything, it's plain as day, verdict in our favor, no need to sit and chat about this. Right? Simple legal issue, this is it, it can be decided right now. If not, it goes to a jury, and jury makes a decision, or it goes to the judge, and the judge decides the case, and there's a variety of different strategies as to why you'd want to take just a judge or go to a jury. Then afterwards, after there is a decision, you might have, we talked about the motion for a new trial, for example, new evidence, whatever it might be. Motion for J&OV basically means, Judge, the jury was crazy. That's a rough translation. Basically, the jury comes out, reaches a decision, and the party that loses says the jury does not know what they're doing. They reached an incorrect verdict. They didn't apply the law correctly. They applied the wrong law. So, which does happen. Then the appeal. We talked about that. Basically, the parties file a brief. Their attorneys represent them on appeal. And it is primarily, it says courts don't consider new evidence. We're not introducing the knife or anything, or any witness. We're arguing legal issues that were decided in the lower court. All right. Electronically. Well, let me just say that, I think the authors, some people make it sound like all the things we're talking about physically could happen online. Michigan has a project to put courts online. Well, it hasn't happened. Some parts of the legal process could happen online. There's video arraignments. There's, court records you can get online through the court. There's a variety of things that are online. But, live trials over the internet, that doesn't happen too much, right? Kind of fun. Maybe you can do it over Facebook. Say you like somebody or something. Post on the defendant's wall. Okay. Maybe not. And then online, we could also have alternative ways of resolving disputes. How much time we got? What time is it? 6 minutes, I can do it. All right, so the rest of these slides talk about alternative dispute resolution. But here, this slide contains the major things that I want you to know. And that is negotiation, mediation, and arbitration. If you are married or have somebody else that you have to resolve dispute with frequently, that's negotiation. You have experience with that. That's where the sides, either themselves or through an attorney, try to resolve the dispute without bringing in a third party. So this could happen at different points. You know, ideally it'd be good to have this happen before you go too far into actual litigation. You try to resolve the dispute without taking it through the court system, without a neutral third party. These last two involve a neutral third party. What do I mean? I mean somebody who's not biased to one of the sides and not one of the parties, whose job it is to offer the sides a decision of some kind. Now, here's the way I define mediation. Mediation is usually not binding on the parties. When I say not binding, I mean like the parties could say, thank you for your recommendation, your decision, but we're going to go forward anyway. Arbitration, binding. Now your authors talk about binding and non-binding arbitration, but what would be another word for non-binding arbitration? Mediation. So think of mediation, non-binding, arbitration, binding. Here's why I define arbitration as something that's binding. Like if the parties get a decision in an arbitration, they're stuck with it. Another way of saying binding. This example illustrates it. Employment contracts. Usually you're stuck with an arbitrator's decision because you agreed in advance to be stuck with it. Look at, if you have an employment contract, look at that. If you have an insurance contract, look at that. If you have a contract with a creditor, look at that. Look at your insurance. There's probably a provision in there that says if you have a dispute with the insurance company, you won't sue them in court about it. You'll take it to some neutral third party to have it resolved. So, let's say you do have a dispute with your insurance company and you sue them. One of the things they could argue as a defense is, this court does not have jurisdiction. Why? Because you signed your right to take it to court away. You agreed that you wouldn't do this. So therefore the court doesn't have jurisdiction. No negotiation, no neutral third party. The parties try to resolve it, perhaps through their attorney. Mediation, neutral third party becomes involved, but the decision is non-binding. I used to be on a panel here in Kent County where there were 3 of us. We were all attorneys, and actual cases would come to us, and we would try to tell the parties what they should do. The parties were free to say, thanks, but we're going forward anyway. If they did and lost, they often had to pay the other party's attorney fees, but they had a right to do that. So these are things that could happen outside the court process. Last thing I want to say about this, though, is that in some cases, mediation is part of the process. Like if you file a claim in federal court here in the Western District, you get started, and often the federal court will say, we're going to send you off to mediation. You know, over here, the idea I suggested at the beginning of class was alternative dispute can save you money. What if you're already in a federal case, then they make you go to mediation, then you're not happy with the result, and then you're back in the case? Well, they just cost you more money, right? So sometimes mediation is part of the process. If you've ever been through any type of family court issue, mediation is fairly common in those type of situations, or custody. All right, let me finish it off with one last term. It's the shins. There's negotiation, mediation, arbitration. The last one is litigation. I've been talking about that for almost an hour and a half, but sometimes people, when they see that term, they go, what's that? Litigation is the actual process of not following one of these alternatives and actually suing somebody and going